Hello, everyone. I I've been away. um, Sorry that I've been away for about. I was looking at this 10 days without a stream. That's bad. Um, Sorry about that. I was at a conference presenting a paper about how you know what was it about? About indigenous revolutions and international law. So it was a nice conference also in Zurich. So if you're around Zurich, uh, let me know and I can recommend you. You know what do you call it? Places to go, things to do. Um, Iconoclast, hi, how are you? Oh, Luna Macias, hi, it's your first time chatting, so welcome to the chat. Hey, Magic of Carols. Something was really missing this past week. These streams really became a rendezvous. Yeah, I know. I really missed you guys. I was hoping that I could, do this over at the on Sunday, but it became impossible because airport delays and stuff. It was not the best. But I am back. I am back, and honestly, it's been interesting to see the channel while I was away. So we are now at what was it, 524 followers, which is insane. Um, we have uh yeah, we are 9 subs away from our subscriber goal and with 3,000 cheers. It's amazing. Thank you so much everyone who has followed me while I was away. There's been Saklu, Vanita Text, and Doucheback, which is kind of funny. Our new followers, so if you're around, say hi. Thank you. Um, we had hit a good number of viewers last time we left off. We had like 30 people watching, so we're gonna have to work a little bit to recover that. Um, Hopefully my absence wasn't too catastrophic. Um, in other news, I for the next stream I will probably have a better webcam, so you will see my face in more. I know Cheese Thief was making jokes about it, but yeah, I have a webcam now. It's not installed yet because it's just arrived. One of my Black Friday purchases. Um, Investing in quality for you guys. um, and then we're still looking for badges. So if you have recommendations or ideas for badges for subscribers, that'll be great. So far, I don't think we've had many suggestions, but something will pop up. Eventually, it'll happen, and we'll just have a um badges for subscribers soon enough. Sorry, it's been taking some while. I go little by little with the channel. So next step was buying the webcam. So which, by the way, thank you for your subscriptions. The last stream, it's what made it possible. So yay, now we have a better webcam, so that I can, not look like the low def version. Someone made this joke that I look like low definition. Um, so other than that, before you guys go on your ad break, what was it? Oh yeah, we need to plan the FIFA playthrough because you guys are forcing me to play FIFA so that I can go mad at the screen for a while. Um, right now, it is a particularly busy time. Magic Carls, yeah, that was the comparison that I am the low definition version of Owen Jones. um, and oh, Muhanusi, sorry about that. Normally I tweet on Thursdays, but for the next 2 weeks I'm gonna need to stream on Wednesday because of a pre-existing commitment. So yeah, I'm glad that you didn't miss it. Maybe that explains why we're low on viewers. Um, oh, geez, Steve, thank you for subscribing again for 4 months. That's great. You give us a view of Kevin the Uniduck. Yeah, normally I do this on Thursdays, but I'm not gonna be able to do this on Thursdays for this week and next week. So I'm switching it. Yes, Magic of Carols. I'm switching it to Wednesdays, and then I'll go back to my regular. Sorry about that. It's just as I was saying, it is a busy couple of weeks for academics because terms are ending, which means two things. Number one, we need to prepare the classes for the next term. They don't just happen. You need to actually plan them, and that's a lot of work. And you need to like find reading materials, and you need to do stuff. So it's really complicated. Um, and second of all, marking. You guys, like Cheese Thief, you're gonna be going into finals, or other kinds of evaluations, and we need to mark them. And so it adds up. I just finished marking my first set of formatives, so it gets intense. So it's a pretty busy day. So I have lots of meetings, lots of like departmental meetings and stuff like that, lots of marking. So I need to move the stream around a little bit. And also I went on a conference, so it's been busy. So I'm sorry about that. But in about 2 weeks, things will calm down again. It'll be the winter break. It will be college closure. And while I will still need to prepare my classes, I probably will be done with marking, so it'll make streaming easier. Sorry to hear that you're cooked for finals, G Steve. um, so I think the ad is gonna end in like 30 seconds, so we're almost done with the housekeeping, and then we can talk about the topic of the day. I'm not sure if I have anything else though. Oh yeah, I did tell you about the camera. I told you about badges. We need ideas for badges, and we need to set up a date for the FIFA playthrough. Hopefully everything will be smoothly in 1 or 2 weeks, and we can plan all of these things together. But anyway, thank you so much for spending your Wednesday evening with me. Um, the topic for today is pretty much something I owed you guys from when I left for Switzerland, because so as you know, the ICC issued arrest warrants against Netanyahu, and there's been a bunch of reactions from states all over the world saying whether they would arrest or would not arrest um, uh, Netanyahu, the Prime Minister of Israel, in compliance with the arrest warrant. So I thought. Um, Normally I would have started streaming right away, but because I was in Switzerland and hotel Wi-Fi sucks, I thought, okay, I'll do it when I return. So here I am, and let's talk about that. Um, oh, Deepen, how are you? Nice to see you again. Uh, Deepen is talking about the Ali Lukes. I think it's Lukes or Lokes. I'm not sure. How many people do you think have read your uh, so for those of you who are confused, Ali Lukes or Lokes, I'm not sure how to pronounce it, um, is a PhD student that recently graduated, I think from Cambridge, if I remember correctly. And she posted on Twitter that she was PhD done, which is a thing that academics do when they finish their PhD and they say they're PhD done. And her thesis was on the ethics of olfactory ethics in prose. So essentially, how is the ethics and the class dynamics and race dynamics of smells, how are they represented in literature? She was a PhD in English, and a bunch of like right-wing trolls started attacking her because they thought they didn't understand the thesis, and they thought that her thesis was about smell equals racist. um, and so a bunch of like idiot blue checks started, going after her. And now she has, I think there's like 90 million views on her PhD done tweet. And it's probably the most read abstract in history. So Deepan is asking how many people do I think have read my PhD thesis, and I don't think it's a lot. If you want to read it, it is available in the UCL Discovery database. You just Google, UCL Discovery Alonso Gurmendi, and like it should give you my thesis. I don't expect a lot of people. Most people don't read PhD thesis. Um, Oh, thanks, G Steve. That's like one of the nicest thing you can say to an academic is I'll read your PhD thesis. um. Oh, hey, Konakas. I'm sorry you don't see your sub, but I don't know. Complain to Twitch. Konakas says she got beyond 100 million milestone views on her tweet. My God, yeah, that is incredible. Yeah, I think it is very important to discuss this in the context of what it is. It is a misogynistic attack on a smart, successful PhD um, scholar who just wants to finish her studies. And I mean, I get attacked on social media a lot, but honestly, it's never as intense as what female scholars go through. So there is a misogynistic component on all of this that we cannot ignore. Um, so I think it's important for other academics to like step up and say this is misogynistic, this is horrible, and you should not be bullying this like early career researcher. Um, Over something that clearly they don't understand. So I've tried to be active on defending her online. Um, Yeah, I think there's no such thing as bad publicity applies to this. So a lot of people have read her research now, and she has like 46,000 followers now, which is always great for an academic, and everyone knows her name. So overall, yeah, unsuccessful attempt at canceling her, but still, I'm sure it was a pretty um uncomfortable couple of days for her. Um, but yeah, okay, so I think this is enough of housekeeping. Shall we start with the topic of the day? Um, so as you know, usually what happens is I try to go through some level of like some general theme. In this case, head of state immunities. And but if you have any questions while I'm talking, just like let me know and I will answer them. Um, I think the main thing to do when we're talking about head of state immunities um, is that they're not the same as state immunities, right? So this is the most basic thing. I'm trying to give like a a relaxed primer on immunity. So states, you cannot. What is an immunity? An immunity is something that prevents a court from attaining jurisdiction, and states have immunity in other states' courts because, like, if you are sovereignly equal to another state, then you cannot try that state in your courts. Essentially, you cannot sue like the UK cannot sue France in UK courts because the UK and France are supposed to be equals, and so there's no power over equals. Deepen, just to give a simple spoiler answer, I no, in my opinion, and this is a complicated conversation. In my opinion, he does not have immunity from the ICC, um, both on account of what I believe, and on account of what the case law says at the moment. So let's get there. Um, Mario Liberum says para imperium non habent imperium. Yes, exactly. So if there's two equals, then you cannot have dominion over the other. This is basically saying it in Latin. So welcome, Mario Liberum. So it's your first time chatting, and I know who you are. So good that you're here. Thanks for coming. Um, so uh, yeah, okay. So continuing with this like chill explanation of immunities. Um, Head of state immunities and head of government immunities are different in the sense that they don't apply to the state itself, but to its head of government or to its head of state. The difference between head of government and head of state is usually a very simple one. Heads of state tend to be more symbolic, sort of like the Queen of England is a head of state. Um, the president of Israel is head of state, whereas the head of government is someone who actually has to like run the government. So the prime minister of Israel or the prime minister of the UK. This is not the case for everyone. So in like Peru, for example, my country, in Peru, the head of state and the head of government are the same person, meaning the president. So it really varies from country to country. So the reason why it's separated head of state immunity and head of government immunity is because of this, right? Um, so Deepan asks, can bad things happen to a country that should arrest him but doesn't? So we'll get there. I'll touch upon that. So don't worry. We'll get to that. Um, so essentially, what we're doing with head of state immunity is saying, look, the state cannot be prosecuted, cannot be tried in domestic courts. So therefore, the people that carry out the functions of that state cannot be prosecuted in the courts of that state either. There has traditionally been some doubt about whether this covers international crimes or not. So um, can a president that commits war crimes, for example, just say, "Oh, I'm immune from prosecution because I committed war crimes, but I'm the president, so you can't do anything to me." So if you are talking about, for example, an absolute monarchy, does that mean that you will never ever get to like prosecute this person anywhere because the state itself will not prosecute them, and you cannot prosecute them outside of the state, and they are head of state for life, right? So should specific crimes be covered by immunity? And I guess here is a good time to point out the difference between like personal and functional immunity. So Um, the reason why these individuals get immunity is because they are performing a function of state, right? Not everyone gets immunity, simple as that. So there are some. Oh, and I think someone, Madam Mirma one is now following. So thanks for following and welcome to the community. Um, so you can heads of states and heads of government and other high officials of the state have immunity um, either on account of their person or on account of their function, right? So personal immunities or functional immunities. Um, and so the question is, while they are in, uh, while they are head of state, while they are head of government, they have immunity both because of the function that they develop, but also because of who they are. They are the head of state. Therefore, um, while they are in government, essentially you basically cannot prosecute them, right? That's the general theory. That's the old ancient theory. And so the question that emerges is, well, wait a minute, but is committing war crimes and committing crimes against humanity actually a function of that role? Or is it just something that is outside of that role and therefore you can cover it with, um, you cannot cover it with immunities, right? So um, that's the big question, right? To see if someone can be prosecuted. And this came up in a case. I'm gonna start my little screen capture here. Um, so this happened in a case. This came about in a case called the 2002 case concerning the arrest warrant of 11 April 2000, where the Democratic Republic of the Congo sued Belgium before the International Court of Justice. Right. So in this case, Belgium had a universal jurisdiction law, meaning that it wanted to prosecute. Um, I think it was the Ministry of Foreign Affairs of the Congo in Belgium, and so the Congo said you cannot do that. The immunities for high officials, head of state, head of government, Minister of Foreign Affairs, immunities cover this person, and you cannot prosecute them in your country. And so this was a good opportunity for the court to sort of like give us like the basics of what the law and immunity is like. So we're gonna go through the text so that I can show you what it says. Of course, if you have a question while I'm talking, as always, just let me know and we can diverge. But for now, um, let's go to paragraph 47. Where is paragraph 47? Almost there. There you go. So this is what the Congo. So usually, what the court does is it says what Belgium says what the well, in this case, says what Congo says. It says what Belgium says, and then arrives at a specific point, at a specific like its own determination, right? Um, so the court said, and I hope you can read it. I think you can read it. I think it's big enough. Let me double check. Yeah, it's big enough. Okay. So the court said the Congo maintains that during his or her term at office, a Minister of Foreign Affairs of a sovereign state is entitled to inviolability and to immunity from criminal process, being absolute or complete. That is to say, they are subject to no exception, meaning that while they are, you know, for a minister, there's nothing you can do. You cannot touch them. According to the Congo, um, accordingly, the Congo contends that no criminal prosecution may be brought against a Minister of Foreign Affairs in a foreign court as long as he or she remains in office, and that any finding of criminal responsibility by a domestic court in a foreign country or any act of investigation undertaken with a view to bringing him or her to court would contravene the principle of immunity from jurisdiction. This is, let's say, the position that most states would want their heads of states to be held against. Like, you cannot prosecute them, period. Okay? Wait, there's a question. So Jarto, hey Jarto, how are you? Says, for ICC signatory states who choose not to arrest war criminals like Putin or Netanyahu, can the representatives of those states, like Macron, be found criminally liable for aiding and abetting or some similar crime? Not for not arresting. Particularly in the case of France, for example, the president has no control over who gets arrested for the ICC. That's for the tribunal. So much of what France is doing in the context of Netanyahu is posturing. It's diplomatic posturing because the president holds no control over the courts. The courts will arrest Netanyahu regardless of what Macron says. What Macron is doing is weakening the rule of law, but he has no control over what happens to Netanyahu. Netanyahu will still not go to, uh, France. So for the fact of not arresting can I will get to it in a second, can get you in trouble with the court itself. But it cannot. It's not a crime for the president to not arrest. Um, so okay, so this is what the Congo said about what the immunities are. Essentially, you cannot touch someone who has immunity, right? Who is in power. Um, So the Congo further states that it does not deny the existence of the principle of international criminal law, deriving from the decisions of the Nuremberg and Tokyo International Military Tribunals, that the accused official capacity at the time of the acts cannot, before any court, whether domestic or international, constitute a grounds of exemption from his criminal responsibility or a ground for mitigating of sentence. The Congo stresses the fact that an immunity might bar prosecution before a specific court or over a specific period. Uh, thus, that an immunity might bar prosecution before a specific court or a specific period does not mean that the same prosecution cannot be brought, if appropriate, before another court which is not bound by that immunity. That is very long way of saying I do recognize that there are some courts that have jurisdiction. It is just not Belgium. Right? Essentially, that's what they're saying. If there's a Tokyo or Nuremberg tribunal, sure, but not Belgium. And this is where this case gets interesting because the court was dealing with two states, right? Belgium and Congo. Belgium and Congo fighting over who had the biggest responsibility to prosecute Yerodia, this like foreign minister for war crimes and crimes against humanity. Actually, crimes against humanity, not war crimes. And so the Congo says, well, maybe at the international level, but not at the domestic level. Belgium, you're not an international tribunal. So interestingly enough, um, the court, this is where the court gives its own opinion, so the court would observe that the outset that in international law it is firmly established that, as also diplomatic and consular agents, certain holders of high-ranking office in a state, such as the head of state, head of government, and minister of foreign affairs, enjoy immunities from jurisdiction of the states, both civil and criminal. So the court is saying these immunities exist, right? For the purposes of the present case, it is only the immunity from criminal jurisdiction and the availability of an incumbent minister of foreign affairs that fall for the court to consider. So it says, I'm going to talk about immunities, right? Um, and the court finds something quite interesting. The court essentially says, yes, there is immunity, but not in all forums. So the court says, paragraph 55, the court says, in this respect, no distinction can be drawn between acts performed by a minister of foreign affairs in an official capacity and those claims to have been performed in a private capacity, or for that matter, between acts performed before the person concerned assumed office as minister of foreign affairs and acts committed during the period of office. So this is a very broad, concept of immunity. Um, If a minister of foreign affairs is arrested in another state on a criminal charge, he or she is clearly thereby prevented from exercising the functions of his or her office. Um, so essentially, you cannot do this, Belgium, right? Immunity still exists for heads of state and for high-ranking officials. That this is basically what the court is saying in this part, right? But there's a big but coming up that's important. The court does say, where is it? Hold on. It's around here somewhere. Okay. So the court says, Belgium, you have to respect immunity for these high officials. There's one key paragraph in this decision that is an interesting one. The court says, where is it? Oh, here it is. An incumbent or former minister of foreign affairs may be subject to criminal proceedings before certain international criminal courts where they have jurisdiction. Examples include the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda. And here's the kick. And the future International Criminal Court created by the 1998 Rome Convention. Right? So this is the court saying, look, states cannot have jurisdiction over another state's head of state, head of government. But an international tribunal can. some international tribunals. I mean, there's some discussion right now going on because, for example, Ukraine is trying to create a specific tribunal to try to try Putin specifically for the crime of aggression, and the argument would be, well, it's an international tribunal, so therefore no immunities. I mean, that remains to be seen because the court doesn't say any international tribunal; it says some international tribunals. Given examples of tribunals with some level of universality in their argument, in their like scope, right? But it does mention specifically the International Criminal Court, right? In fact, it says the latter statute explicitly provides in Article 27, Paragraph 2, and we'll look into this in more detail, that immunities or special procedures or special procedural rules which may attach to the official capacity of the person, whether under an national or international jurisdiction, shall not bar the court from exercising jurisdiction. Right. So essentially, Article 27 of the ICC statute says there's no such thing as immunities um, that are applicable for the court. So from this, you sort of get the idea of, oh, this is pretty straightforward. There are no immunities. Done. It gets a little bit more complicated though, but I did want to start with this case so that you guys understand um, where we're at in terms of like where immunity comes from. There is immunity for heads of state. All states need to respect it, but under international law, um, international tribunals are subjected to or can be subjected to different rules. This was controversial because of what I said, because like can Ukraine just sign a treaty with another state and say, okay, now I want to try, I can try whoever I want? It probably was not the most uh, straightforward, easy way to get to the same point of we can have accountability for international crimes. My own view is more on the lines of these crimes are special, so we shouldn't afford them protection. But I'm not the court, so the court said what the court said, and this is the regime that we have right now. Okay. Um, hold on. There's a question in the chat. MG Jar, it's your first time chatting. Welcome to the community. Says, how can combatants defend in urban areas without committing the crime of using civilians as human shields? Well, I mean, if you go to my YouTube page, because I'm pretty sure it's no longer on Twitch, if you go to my YouTube page, you can find there a video called International Humanitarian Law. In that video, I go into detail about this. Essentially, there are various principles that apply to determine when you can actually strike a target, when this is, valid or not. In the specific case of Israel, the main problem is one of means and methods of war, in that even before we get to the discussion of whether this specific strike was legal or illegal, the fact that Israel was using 2,000-pound bombs and establishing kill zones in Gaza and like forcefully evacuating people with no consideration or no humanitarian consideration means that most likely they will fail any legal test. Even before we get to a more nuanced discussion on proportionality and distinction, because you're using 2,000-pound bombs, which have an impact radius of the size of a stadium, to kill one person. Muhanusi says, sorry to digress, no problem, we digress all the time in this channel. But under universal jurisdiction, will the arresting country be prosecuting under its domestic law or international law? So usually, in universal jurisdiction cases, it's the domestic law of the country that applies. It's just that domestic law is generally adapted from the Rome Statute. So usually, it's implementing legislation that says let's make the Rome Statute domestic law. This is not the case for every single country, but it's the ideal. So yeah, domestic law, but that domestic law is very similar to international law. Okay, so we're at we're at this point where the International Court of Justice has said that there are immunities for heads of states. That states cannot just prosecute someone else's head of state in their own domestic tribunals, but the international tribunals might, and it specifically referenced the ICC. Right. So let's look at the ICC. Right. What does the ICC say about immunities? And there's a big theoretical discussion about this. and there's a lot of case law about this. So as far as like positive law goes, like as far as what legal standards tell us, this question has been settled by the court. Of course, I'm not really a legal realist, so if you disagree with the court, that's perfectly fine. Just, you know, uh, just know that um, whatever I'm gonna tell you now is, you know, what the court has said about its own jurisdiction. The ICC, what the ICC has said about its own jurisdiction. Okay. So let's look at the Rome Statute. What does the Rome Statute, the treaty that establishes the ICC, say about immunities? And so I have it here. The first relevant part of the Rome Statute is Article 27. It says very clearly irrelevance of official capacity, which is like already pretty obvious, right? It tells you where it's going. So what the article says is, I'm going to read it slowly and then I'm going to explain. Says this statute shall apply equally to all persons without any distinction based on official capacity. So if you're a member of the ICC and your head of state commits a crime, their official capacity doesn't matter. It says in particular, official capacity as a head of state or government, a member of a government or parliament, an elected representative, or a government official shall in no case exempt a person from criminal responsibility under this statute, nor shall it, in and of itself, constitute a grounds for reduction of sentence. So essentially, those immunities that the court said, the ICJ, the International Court of Justice, said that existed, don't apply to the ICC whenever it goes after a whenever it goes after a head of state or head of government. I just noticed that you guys are in an ad, so I'll probably go through this again in a bit so that you guys don't miss the information. But if you don't want to have ads and you want to get the full version of this, you can subscribe. um, so essentially, what this article says is that um, you cannot oppose to the ICC head of state or head of government immunity, or general government immunity from prosecution. Um, so the let me put it this way: the key part of this is with regards to states that have accepted the ICC statute, meaning member states of the ICC. All of them, every single member of the ICC, all of them have accepted this principle. So let's say that Macron goes crazy and starts committing war crimes all over the world. Under Article 27 of the ICC, he would not be protected by head of government immunity from the ICC. Okay, so this is really important as a principle because I don't know if I can show you how many ICC members there are, but like ICC member states. Uh, there you go. So in that map, you can see. I lost the map. Hold on. Yeah, in that map, you can see that there's a bunch of states, all the green states. All of those states have agreed that their heads of states do not have immunity from prosecution at the ICC. If they commit a war crime, then and they don't prosecute them, then the ICC can take over, right? In all of the green areas, thanks to Article 27, right? Uh, so what is the catch then? Why is this such a why are people even discussing whether Netanyahu has immunity or not? Well, the main issue, the main point here is that Israel is not a member state of the ICC, meaning that Israel has not signed the Rome Statute, right, or ratified the Rome Statute. So it's not bound by that article, right? So what does the Rome Statute say about that situation, about that instance, about that case, let's say? What happens when there's a state that hasn't ratified the Rome Statute and their head of government commits a bunch of crimes, right? So to do that, we need to go to another article. And I know this is kind of dry, like article by article, but I promise it builds up. It builds up. It's unfortunately I need to teach you law for you guys to understand, um, international criminal law. But let's go to Article 98 for a second. Ish, taking a while. Okay. So this is Article 98 of the Rome Statute. Hold on, let me. There you go. That's better. I think you can read it well. Yeah, you can read it well. Okay, cool. So Article 98 of the Rome Statute is designed um, to regulate cooperation with respect to waiver of immunity and consent to surrender. Okay, so this is specifically designed to regulate what happens when there is immunity to consider. Right. So for a lot of states, and for a lot of like interpreters and legal scholars, this relates to, okay, if you're not a member of the ICC, your your state's immunities over its head of state are still existing because you have not signed a treaty that says that they do not exist. So what do we do with them, right? So this is the article that deals with that. And let me read it like really slowly. Hold on. Deepan says teaching us law may take a while. No, I actually, in my experience, you guys picked this up really quick. Um, so Article 98 says, let's read it together, okay? The court may not proceed with a request for surrender or assistance, which would require the requested state to act inconsistently with its obligations under international law with respect to state or diplomatic immunity, or a person or property of a third state, unless the court can first obtain the cooperation of that third state for the waiver of immunity. Right? The court continues may not proceed with a request for surrender, which would require the requested state to act inconsistently with its obligations under international agreements, pursuant to which the consent of the sending state is required to surrender a person of that state to the court. In very complicated language, this basically says, look, state, if you have to deal with immunity, when I tell you, hey, I am requesting you to surrender someone, um, you follow this article. And this article says that the court cannot proceed with a request to surrender, so a request to surrender a suspect, which would require the requested state to act inconsistently with its obligations under international law with respect to diplomatic immunity. Right. So if there are immunities, the court cannot really proceed. So the argument here would be, oh, Netanyahu is not a member of the court. It's not the prime minister of a state member of the court. Right. Therefore, he still has immunities under international law. Therefore, you cannot prosecute him at the ICC. So that would be the logic. The way the Articles 27 and 98 would operate together in this very like fast reading that I'm doing is one of the options is there are no immunities for leaders of member states, but there are immunities for leaders of non-member states. Right? That is one possible reading. Okay. So back in when was this? Let me see. This is another case. Back in this is it. Back in 2019, the ICC. This is an ICC decision. Here, the one that I'm holding in the screen. The ICC dealt with a problem. It had issued an arrest warrant for Bashar al-Assad. Not Bashar al-Assad. Sorry, for Omar al-Bashir. Sorry, I'm thinking of Syria lately a lot. It had issued an arrest warrant for Omar al-Bashir, the president of Sudan, and al-Bashir visited, here you go, visited Jordan. Jordan let him come and let him go away and did not arrest him. And so the court was like, "Hey, well, why?" The prosecutor was telling the court why would Jordan do that? That is in violation of Jordan's obligations under Article 27 of the ICC statute. Courts, do something, right? Court, do something, and uh, essentially the pretrial chamber of the ICC sided with the prosecutor, saying, "Yeah, you know what, Jordan, you sort of should have arrested Omar al-Bashir." Uh, and Jordan said, "No, you're crazy. You're reading the law wrong. So I'm going to appeal." And so this is the appeals decision. I'm highlighting that part over there. This is the appeals um, decision of the Jordan case. So of the Jordan case in the Darfur Sudan situation. So that we don't need to say that in such a long way, usually this is called the Jordan appeals decision, right? So the Jordan appeals decision is when um, Jordan appealed to the appeals chamber of the ICC against the decision of the pretrial chamber that sided with the prosecutor in the situation where al-Bashir went to Jordan and wasn't arrested. Very long story, right? Um, but this was it, right? This is that decision. So what happened in this decision? So this is the key case where the ICC sort of um, decided how to read Articles 27 and 98 together, how to interpret them systemically, how to make them make sense, if you will, right? So let me take you to paragraph. What paragraph is this? Almost there. Paragraph 47, I think it is. Right. So just to set up the scene, says the pretrial chamber. This is the appeals chamber talking here. The pretrial chamber determined first that Jordan had failed to comply with its obligation under both the Rome Statute and Resolution 1593. Resolution 1593 of the Security Council was the decision that submitted the situation in Darfur to the ICC in the first place. So, how did Sudan, a non-member state of the ICC, end up in the ICC? Well, the Security Council went to the ICC and said, "ICC, I am giving you jurisdiction over Sudan." Um, and so the pretrial chamber said that Jordan had violated its obligations under the Rome Statute, so Article 27, and the resolution of the UN Security Council by not executing a request by the court for the arrest and surrender of Mr. al-Bashir, and second, that Jordan is to be referred to the Assembly of State Parties and to the UN Security Council. This is the consequence that you guys were asking me about. That Jordan would be referred to the Assembly of State Parties and to the UN Security Council because it did not comply with its obligations, right? So the pretrial chamber determined that Mr. al-Bashir enjoyed head of state immunity from the exercise of criminal jurisdiction by Jordan under customary international law, reiterating its decision in the case of South Africa, in which it held that it was unable to identify a rule in customary international law that would exclude immunity for heads of state when their arrest is sought for international crimes by another state, even when the arrest is sought on behalf of an international court. Um, so, to give you an idea of what happened, oh, sorry, Jartov says, did the UNGA or the UNSC grant the ICC jurisdiction? The UNSC did. The United Nations Security Council referred the situation in Darfur to the ICC. And that's how Sudan ended up in the ICC, even though Sudan never ratified the Rome Statute. Um, where was I? Oh, right. So the pretrial chamber starts by saying, look, you know that ICJ ruling? Yeah. So al-Bashir has head of state immunity. It exists with regards to Jordan. Right? However, says the pretrial chamber, meaning the prior decision, it found that Article 27.2, which we just read, of the statute not only prevents immunity from constituting a bar to the exercise of the court's jurisdiction, but it also excludes immunity from arrest. Right? In particular, in the pretrial chamber's view, the effect of the provision is twofold. It prevents state parties from raising any immunity belonging to it under international law as a ground for refusing arrest and surrender of a person sought by the court, vertical effect, and two, invoking any immunity belonging to them when cooperating in the arrest and surrendering of a person to the court provided by another party, the horizontal effect. So essentially, what the pretrial chamber did was say, look, there are immunities with regard to Jordan, but I cannot find immunity with regards to the ICC because of Article 27.2 of the statute. Right? Um, so it's sort of like vanished those immunities. And so a lot of people were saying, like, but how can the court do that? Like, under what rationale did the court do that? And one thing that was very noticeable in the pretrial chamber's decision was its reading um, of Security Council resolutions. It said the pretrial chamber was of the view that while the regime set out in 27.2 ordinarily applies with respect only to state parties, which is what we were discussing, only states that ratified the ICC um, statute renounce immunity for their leaders. The statute provided for obligations to find hearing. Uh, the statute provided for obligations to find hearing may become incumbent upon the state, not as a result of its acceptance, but as a result of and under the Charter of the United Nations. In the present case, the pretrial chamber found that the court's jurisdiction under Article 13b of the statute was triggered by Resolution 1593. So essentially, the pretrial chamber was saying, oh, wait a minute, there can't be um, immunities here because by referring this to the Security Council, by referring this to the ICC, the Security Council was saying that there would not be any immunities either, because it was referring Sudan to the ICC. Therefore, in that act, it was destroying Sudan's immunities for al-Bashir. The very act of being submitted by the Security Council was the key thing here that meant that there was no jurisdiction, no immunity from jurisdiction for al-Bashir, right? Let me know if this is getting confusing, because I know this is usually I talk more freely, and in this case I'm just reading articles, so let me know if you guys are following. Um, but yeah, but so essentially what it said here, the pretrial chamber said, um, look, I don't think that heads of state have immunity in cases of war crimes and crimes against humanity, but even if they were removed by the Security Council, the Security Council's referral, right? So what happened then? Let me go to paragraph 95. Where is paragraph 95? Ooh, I'm almost there. So the appeals chamber sees this argument, sees this thing that the pretrial chamber did, and gives its own opinion. Right? This is now not the pretrial chamber talking. This is now the appeals chamber deciding whether the pretrial chamber did the right thing. Okay. So the appeals chamber says that Jordan, so the state appealing, Jordan submits that the pretrial chamber made erroneous findings regarding the effects of the statute on Mr. al-Bashir's head of state immunity. Notably, Jordan alleges that the pretrial chamber erred in finding that Article 27.2 of the Roman Statute excludes the application of Article 98. Remember, not Article 98 dealt with like if immunity exists, right? Um, and then a bunch of other things that like Jordan was not happy about. um, so let's look at. Hold on, this is not what I wanted to read. Yeah, this is not what I'm reading. Hold on. Paragraph 113. So the appeals chamber said here fully agrees with the pretrial chamber one's conclusion in the Malawi decision as well as that of the it's not important in the Taylor case, and notes that there is neither state practice nor opinion juris that would support the existence of head of state immunity under customary international law vis-a-vis an international court. So the appeals chamber is saying if there is an international court, there is no immunity. Period. Right? And I agree with the pretrial chamber. To the contrary, continues the appeals chamber, as shown in more detail in the joint concurrent opinion by judges Eboye-Suji, Morrison, Hofmansky, and Bosa, such immunity has never been recognized in international law as a bar to the jurisdiction of an international court. Right, so basically saying if there is an international tribunal that is prosecuting international crimes, you cannot have immunity from that prosecution. To be noted that in regards to this is to be noted in that regard is the role of judicial pronouncements in confirming whether or not a rule of customary international law has, as such, crystallized. The appeals chamber is satisfied that the pronouncements of both the pretrial chamber in the Malawi decision and the appeals chamber of the Special Court for Sierra Leone have adequately and correctly confirmed the absence of a rule of customary international law recognizing head of state immunity before international courts in the exercise of jurisdiction. So essentially what it says here in very complicated terms is we have not been able to find a rule that says that you should oppose immunity vis-a-vis an international court. So if there's an international court, then there is no immunity. Right? The absence of a rule of customary international law recognizing head of state immunity vis-a-vis international courts is relevant not only to the question of whether an international court may issue a warrant for the arrest of a head of state and conduct proceedings against him or her, but also for the horizontal relationship between states when a state is requested by an international court to arrest and surrender the head of state of another state. Oh, hey, Boulevard Dreams, how are you? So essentially, the appeals chamber is saying there are no immunities because this is an international court, right? There's no rule that recognizes head of state immunities vis-a-vis international courts. So says the appeals chamber notes further that given the fundamentally different nature of an international court as opposed to a domestic court exercising jurisdiction over a head of state, it would be wrong to assume that an exception to the customary international law rule of head of state immunity applicable in the relationship between states has to be established. Rather, the onus is on those who claim that there is such immunity in relation to international courts to establish sufficient state practice and opinion juris. Essentially, it says here, if you think that there is such an immunity before international court, then you need to prove it. I don't need to prove it. You need to prove it that such a rule exists, and it just doesn't. So this was very controversial for the reason of saying any court, any international court, if two states get together and say, I'm going to prosecute, if, I don't know, Peru and Bolivia get together and say, I'm going to prosecute the president of Brazil, just because it's an international court, is that enough? And so there was a lot of discussions about this among academics, and generally it is believe that it's not just any court, which is relevant for the Ukraine discussion regarding Putin, because Ukraine sort of like, because Western powers do not support the ICC going after Putin for aggression, they're trying to create a new court. And so this becomes a problem because like any court cannot be the response. Not every international court can, remove head of state immunity like this. But essentially what we are getting from what the appeals chamber is saying is when there is a very legitimate court, very international court, then yeah, the immunity doesn't exist. This is, I guess, not the strongest argument, but it is the argument that was approved by the appeals chamber, the pretrial chamber, and also the special criminal tribunal for Sierra Leone. And so the court is saying there's enough here for me to say that yeah, when there is an international court, then there's no immunity for heads of states. Iconoclast says, are the UN as an international body considered a member of the ICC so they can grant it jurisdiction? So the UN is separate from the ICC. The ICC is not an organization that's part of the UN, so no. But the Security Council has like very powerful powers, essentially. So they can give the ICC jurisdiction, both because of what Security Council powers are, but also because the Rome Statute so authorizes it. The Rome Statute says even though we're not, a UN court, the UN Security Council can refer situations to us because we want to cooperate with the UN. Let me go further down. So the court is saying there is no immunity before international courts. So Article 27 is not just reflecting, an obligation in the Rome Statute. It is just saying generally there's no immunity. Right. So when reading Article 98, the appeals chamber says the appeal chamber recalls that pursuant to Article 98(1) of the statute, the court shall not make a request for surrender when it would require it to act inconsistently with its obligations under international law with respect to the state or diplomatic immunity of a person or property of a third state. In other words, the court may not, without first obtaining a waiver of immunity, request a state party to arrest and surrender the head of state of another state if that would require the requested state party to act inconsistently with its obligations under international law. So here's the thick of it, right? Here's when we're reading 27 and 98 together. The court is saying, look, if it would violate your immunity obligations to arrest the president of another state, then yes, the Rome Statute would ban that. But, it says, it must be underlined, however, that Article 98(1) of the statute does not itself stipulate, recognize, or preserve any immunities. So what the court is saying is the immunity of heads of state is not produced by Article 98. Article 98 does nothing here other than say if the immunity exists elsewhere, then you need to respect it. Right? And so because the appeals chamber already said that before an international court there are no immunities, Article 98 cannot preserve any such immunities. Right? That's what the court is saying here. What the court is saying is Article 98 exists in case there is an immunity. But I've already determined that there are no immunities in international courts. So there's no immunity. So for the appeals chambers, it is a procedural rule, Article 98, that determines how the court is to proceed where any immunities exist, such that it could stand in the way of a request of cooperation. Accordingly, the existence of immunities must be established on the basis of the court's sources of law, pursuant to Article 21(1) of the statute. As noted above, Article 27(2) of the statute prevents any reliance on head of state immunity both vertically in the state party's relationship with the court and horizontally in the relationship between states parties when cooperation is sought by the court. As a result, in the absence of head of state immunity, Article 98(1) of the statute is not on its own right a fountain of immunity. In those circumstances, no waiver is required and there is no immunity to be waived, as there is no immunity to be waived. So what the appeals chamber is saying here is, look, wait a minute. Article 27 says there are no immunities before this international court, and any international court for that matter. It doesn't matter if you're a member or not of the ICC. International courts generally are created to prosecute these kinds of people, so why would you have immunity for these people? So from the moment that there's an internationally recognized, very legitimate court that prosecutes war crimes and crimes against humanity, heads of states lose their immunity vis-a-vis that court. It doesn't matter if you ratify or not the Rome Statute, because the ICC is such an international court, then there is no immunity. And then the question goes, but then what about Article 98? Article 98 supposedly says that you need to preserve immunities wherever you need to comply with them. What the ICC says is, sure, if there were immunities for heads of states, you would not be able to arrest them. But because there are no immunities for heads of states, you don't need to comply with that, you can arrest them. So the very easy response that people have to this is, oh, so Article 98 means nothing. It does nothing. It has no content, right? It's just there, but it really does nothing to prevent the arrest of an international leader. Right? So the appeals chamber addresses this. It says the above reading does not deprive Article 98 of meaning. Article 98.1 of the statute is indeed, as stated by Jordan, a conflict avoidance rule, ensuring that state parties are not placed in a situation where their cooperation obligations require them to breach an obligation owed to a third state. Article 98 remains an important procedural safeguard as it requires the court to consider whether a requested state owes an obligation to a third state before proceeding with a request for arrest or and surrender or any other request for cooperation. Nevertheless, Article 98.1 provides no basis for the presumption that immunity exists. It merely imposes a procedural requirement for the court to consider whether any international law obligation exists and applies with regards to the requested state in a particular situation. Right? So what the court is saying in this paragraph is saying, look, it's not that it doesn't have any meaning. It's just that it doesn't have an application, a concrete application for the case of head of state immunity. So in what situation would Article 98 apply if it is not to prevent a head of state from being arrested pursuant to an ICC arrest warrant? So take, for example, the case of you needing to arrest that president. Let's say you need to arrest Netanyahu in the British embassy in, I don't know, France. Right? In that case, the UK has immunity over its own embassy. So the ICC would not be able to then say there is no such thing as diplomatic immunity in the premises of the embassy, so you cannot arrest Netanyahu in that. So you can arrest Netanyahu in that embassy because I don't care about immunities. Under international law, embassies have immunity, so you cannot just send the police to, arrest Netanyahu in the British embassy in Paris. The ICC would not be able to request French authorities to violate the immunity of the UK to arrest Netanyahu. Or say, for example, that you need to interrogate the ambassador to the UK for prosecuting Israelis. So you need to prosecute the ambassador to the UK in Israel. That ambassador has his own immunity under diplomatic immunity law. So you cannot really just go there and say, hey, let's say that this person is in France again. Hey, French authorities, go arrest the British ambassador because he needs to cooperate with my investigation and he's refusing because he says he has immunity. You can't do that because there the immunity exists. But Netanyahu himself, as the Prime Minister of Israel, does not have immunity, either functional or personal, when he is sought out by an international court like the ICC. So because that immunity does not exist, Article 98 is not in any way keeping you from arresting him. That's the state of things. Right? It all depends on whether there is immunity from prosecution for international crimes in international courts or not. There are a lot of scholars that disagree with this Jordan appeals ruling, that say just being an international court is not enough to deprive someone of immunity. Others agree and say, well, why not, right? Because if the object and purpose of these international courts is to prosecute states and state officials, then immunity would be a silly rule to uphold. Others say, look, it's not necessarily that there is no immunity before international courts because it is an international court. It's because it is an international crime. It's because these crimes are so heinous that we cannot protect them through immunity anywhere, international or domestic. That is a different position that did not win in the appeals chamber. So, sort of what we have here is an evolution of the ICJ's original order in 2002 that said, look, immunities exist, but only vis-a-vis states. Now, there are some international courts where these immunities don't exist, like the ICC. And the ICC takes that and says, in my own view, my own statute does not prevent me from arresting people like Omar al-Bashir, because he doesn't have immunity, because the ICJ said that there's no immunity in international courts. And so therefore I don't have you don't have immunity before the ICC, and I can arrest you. And Article 98 does not prevent me from doing it, because if I read Article 98 as preventing me from doing it, then the ICJ would have been wrong. So reading this systemically, one court enabled another court to say that there was no immunity. So while there is a reading of international law that says, look, Article 27 removes immunity from member states, Article 98 protects the immunity of non-member states, therefore you can arrest Macron under Article 27, but you cannot arrest Netanyahu because of Article 98, that is not the position that won out the law, the case. The position that won out the case was, under Article 27, we are recognizing the principle that under international courts, in international courts, there's no such thing as immunity for heads of state or heads of government. Therefore, Article 98, which is there to protect, diplomatic immunity or the immunity of ambassadors from third states, cannot do anything to prevent the arrest of Netanyahu because there's no immunity to preserve. Those were the two main points here, the two main positions in conflict. And in the appeals, in the Jordan appeals decision, the one that won was the second one, which was arguably at the time the least popular one. But it's the one that won. So in the ICC's framework, that's how things operate. That's what everyone is subjected to. The court has already made up its mind. You can absolutely say that this is the wrong decision and disagree with it. You can totally say that this is wrong and disagree with it, but you cannot say that that is not how the ICC operates. Right? So I'm not a legal realist, so I don't think that courts have the final say on the law. So sure, the court can be wrong, but I do think it is fairly reasonable to say these are the rules that everyone is playing by. Everyone is subjected to the same rules that Omar al-Bashir was subjected when he visited Jordan, and Jordan didn't arrest him. The prosecutor sued Jordan before the ICC, and the prosecutor won. So Jordan was thought to be in violation of the ICC under the ICC's framework. And so from then on, this is how the court has operated ever since. To give you an idea, as recently as October 24th, 2024, the ICC, the pretrial chamber of the second pretrial chamber of the ICC, applied this framework against none other than Putin in the situation in Ukraine, because Putin recently visited Mongolia, and Mongolia did not arrest Putin. So what did the pretrial chamber say with regards to this? Right. Let's go to paragraph 26. The pretrial chamber said, Article 27 of the ICC statute, remember the one that says that there's no immunity, Article 27 is placed in the third part of the statute titled General Principles of Criminal Law, lays down the fundamental principle of irrelevance of official capacity and represents the primary obligation within the statutory framework, which must be considered together with the preamble of the statute when engaging in the interpretation of the statute in light of its content and purpose. So it says Article 27 is very important. Right? The importance of Article 27 is highlighted by its critical role in promoting accountability for serious crimes. This provision creates a binding legal obligation for state parties to uphold its tenets in both domestic and international contexts, ensuring that the objectives of the statute are fully achieved. By mandating accountability without exception, Article 27 strengthens the integrity of the international legal framework and reinforces the commitment of state parties to combat impunity for the most serious crimes of concern to the international community. Consequently, Article 27 of the statute has the effect of removing any and all international law immunities of officials, including heads of states, and binds to that effect states parties, as well as states that have accepted the court's jurisdiction, not to recognize any kind of immunity or apply special procedural rules that they may attach to any persons. Whether these persons are nationals of state parties or nationals of non-state parties is irrelevant. So this is October 24th, right? Whether the people that are being sought are nationals of state parties or not is irrelevant. The statute, in any case, does not make any distinction in this regard. State parties and states that have accepted the court's jurisdiction have therefore the obligation to arrest and surrender any person for whom the court has issued a warrant of arrest, irrespective of their official capacity and nationality. So this says if the president of a non-state party is in your territory, you have to arrest them. Like if one of these people that is sought by the ICC and they are the president of another country is in your country, you have to arrest them because of Article 27. Um, says any arguable bilateral obligation that Mongolia may owe to the Russian Federation to respect any applicable immunity that international law may allow to heads of states is not capable of displacing the obligation that Mongolia owes to the court, which is tasked with exercising its jurisdiction on grave crimes of international concern that threaten the peace and the security of the state parties to the statute and even of the international community as a whole. Given its nature and purpose, such a multilateral obligation cannot be altered or superseded by any bilateral commitments that may conflict with the Rome Statute's perspective. So essentially it's saying the Rome Statute is more important. So he says, while personal immunities operate in relations between states, they do not protect individuals, including heads of states, from prosecution by international criminal courts. This is what the appeals chamber said in the Jordan appeals case. Right? The chamber recalls that the rationale for foreign state officials being entitled to raise personal diplomatic immunity, consistent with the Vienna Convention, is preventing the use of prosecution by national authorities to unduly interfere and limit the free exercise of the functions of the state organs mandated with operating on the territory of another state and therefore impede the concerned state's ability to freely engage in international action. So if another state arrests your president, they are sort of messing with your international relations. So if another state that is your equal arrests your president, they are sort of acting unfairly towards you. But this situation does not arise with the International Criminal Court, which is inherently independent of states, strictly impartial, and acts in the general interest of the international community. So if the international community is telling you that your president is a war criminal, then it really doesn't matter if like you think sorry, if your president is a wanted war criminal, it really doesn't matter if his international functions as your president would be affected. The International Criminal Court is not at risk of being this partial being that is going to affect your foreign relations for calculated reasons. It's supposed to be independent and impartial. Right? So the rationale that leads the ICJ and the appeals chamber to say no, immunities exist with regards to states doesn't apply to international tribunals. This is what this is saying. So just to go a little further down, unlike Article 27.1 says the chamber, Article 98.1 does not make reference to heads of state. The latter is a purely procedural provision according to which the court may take into account certain state pre-existing obligations in the context of requests for cooperation. The wording and the context of Article 98 suggests that it refers only to acts of government activities which are typically conducted abroad and are protected by the safeguards on diplomatic immunity for certain officials and buildings. So this is the key one. This is the article that is restating the Jordan appeals decision. It says, look, there were two readings of international law. Under one, Article 27 removes immunity for member states, and under another, and Article 98 protects the immunity of non-member states. But the way the ICC reads it now is Article 27 recognizes there is no such thing as immunity in international tribunals, whether you are a member or not. It doesn't matter if you're a member or not. There's no immunity in international criminal tribunals. Article 98, therefore, does not affect head of state immunity because it doesn't talk about heads of state immunity. It just preserves whatever immunity already exists. And since immunity doesn't exist in international tribunals, there's nothing to do. There's nothing to protect. Right? It will protect the immunity of an embassy. It will protect the immunity of an ambassador of a third state. It will not protect the immunity of a head of state wanted for war crimes at the ICC. So that's how you read Article 97 and Article 27 and 98 together, right? So in the present circumstances, um, the chamber says, by granting personal immunity to Mr. Putin for the purposes of the implementation of the request for cooperation, Mongolia has acted inconsistently with its international obligations under the statute, thereby preventing the court from exercising its functions and powers under the statute. Indeed, in the court system, the presence of the suspect is required for a trial to take place, and any bar to the execution of an arrest warrant. In other words, if you don't arrest him, then the court cannot try him. There is no such thing as a trial in absentia in the ICC. So, um, Mongolia's failure to cooperate with the court in the arrest and surrender of Mr. Putin is particularly serious. So the ICC is saying here you should have arrested Putin. So essentially, what we have now, what we have in the course of like international law as it is right now, is that there is no immunity from prosecution at the ICC. So when the ICC issues arrest warrants against Netanyahu, it does so in full knowledge that these arrest warrants were already issued for Putin and for Omar al-Bashir, and recently also for in the case of Myanmar. So this isn't some rogue court that has decided that it's going to do some crazy thing that no one ever thought possible. It's done it before, and it's gotten pushback, and it went on to examine its own case law, examine its own foundational documents, and concluded that it does have the ability to arrest heads of state. So honestly, this is very clear. You might disagree with the Jordan Appeals decision. As I said, many scholars do. But you cannot say that this is not the state of the law right now. So it is not a rogue court. It is not a crazy court that is doing crazy things. It is a court that is doing something that it did already many years ago, and it's done it consistently to Sudan, to Russia, to Myanmar, and now to Israel. So to the question, does Netanyahu have immunity from prosecution at the ICC? The answer is very simply no, he does not. Not under the ICC rules as interpreted by the ICC in the ICC case law. So, again, you might disagree with that. You might say, I wish it were different. Or I think the court got it wrong and it is different. You can say that. That's fine. But you cannot say that you don't have a legal obligation to arrest someone. You do. All member states do. Right? So this is essentially the state of the question with head of state immunities. So, was this clear? Because I noticed that, like, unlike other times, chat has been like very silent, and I think chat has gotten traumatized with law, and people here are gonna be like very scared of the law from now on because I that was a lot of articles that I read. So sorry about that. That's what I actually that's what I used to do for a living. Iconoclast says it's so interesting. I'm glad it's interesting because like um it's um uh it's the kind of thing that I wish the media um you know gave us time to explain. Because I've done this in an hour and 15 minutes with basically no preparation. So what I did before this stream was like I opened up all the decisions that I already knew were there, and I sort of made a note of like look at the index and said this is where the specific paragraphs are, and I started reading. So imagine seeing this in the media. I don't think this has ever been explained in media. Mustafa says quality lawyer work. Yeah, I mean, when you're a lawyer, you sort of become an expert in like fast surfing documents. Like this is all stuff I've read before, so like I sort of like knew my way around the documents. Um, but like it does blow my mind how like this is just absent from the conversation. The conversation is on the world of should a court issue an arrest warrant, and I think that's a valid decision. a valid discussion. You can actually question the court's ability to, you know, issue arrest warrants for sitting heads of state and heads of government. I think that's a discussion worth having, sure. And I think, but I think that um, the discussion cannot avoid the is part of the equation. Is it currently the case that it can? Yes, absolutely, out of the question. There's no discussion that it can. So when we hear this like debate in the media about this rogue court that is like out of its mind, how could it do this? Very clearly, it isn't a rogue court. It's been doing this for a while. You just some people are only just now paying attention. Um, so XV78N says, don't know how familiar chat is with theory, but you said you're not a legal realist, if I'm not wrong. What does it mean, and how does it apply? Read legal debates on the on the G side. um, so right, so legal realism is the school of thought that says that um, the law is whatever the courts say. It's sort of in the name, right? It's realist. So essentially, the law doesn't exist until a judge says that it exists. If it's in a, if it's in the writings of legal academics, that's not law. Even the rules, even legal rules, are not exactly law because a court hasn't officially said that they are actually law. So legal realism maintains that the law is only law when a judge looks at it and says, this is law. That's not me. I don't believe that courts are infallible. I don't believe that courts always get it right. I don't believe that whatever courts say is the ultimate interpretation of the law. I much rather like to believe that there should be no immunity for international crimes because they are international crimes. I don't believe that it is the function of a president to commit war crimes or to commit crimes against humanity. And therefore, I don't believe that presidents should have functional immunity over them. And I don't believe that individuals should be protected from accusations of war crimes and crimes against humanity while they hold office. So my position is more like I don't believe that these crimes should be protected by international law. I think we have decided that these crimes are special. We have decided that these crimes are jus cogens, that they are the worst things that someone can do. So immunity cannot be a bar to prosecute them because immunity is a procedural rule. It's not even that important, right? So we cannot do that. So I'm not exactly on camp. Just create an international court and that's it. I can accept the argument. It's I guess with the qualifier that not just any court. It's a reasonable argument. Not just any court, but like say let's establish which kinds of courts. I can live with that. I accept that. Um, I still don't like the idea that then these people will be not prosecutable in domestic courts. I think they should be able to be prosecuted in domestic courts. But I can accept the argument that an international court would say that there's no immunity in international courts. It sort of makes sense. Um, but I mean, my view is more like that's what the ICC said, so that's what we're gonna do at the ICC. That doesn't mean that that is quote unquote international law. That there's no way of counter arguing it. I don't think that. So in the case of genocide, for example, the ICJ has said that Serbia did not commit genocide, other than the specific genocidal act of Srebrenica. I don't care what the ICJ said. For me, Serbia committed genocide, like very clearly so. And that the court said that it did not doesn't change my determination because I'm not a legal realist. I don't care what the court said. I still believe that it was genocide. The only consequence is that in the ICJ system, they won't have been considered to have committed genocide. for the ICJ. But my opinion uh, is that the ICJ got it wrong. That's my legal opinion. The ICJ is mistaken. So I don't subscribe to legal realism because I don't trust courts. So courts are not all knowing, all wise. Courts are institutions, and there are institutions that operate in specific structures, and those specific structures are usually dominated by specific mind views and specific gazes. And so generally, those with power tend to define the law. The law has a specific quality. It's called legal indeterminacy. And I'm of those that believe that the law is radically indeterminate, meaning that it doesn't have an objective meaning. You can say um, no. You can see a sign that says um, no animals in the park, right? And you want to go in um, with your dog into the park, and you see the sign that says no animals in the park. You can make an argument that says that the real intention of no animals in the park was to ban animals that were dangerous. Because it cannot mean no animals in the park, period, because there are squirrels in the park and there are pigeons in the park, and there's no one trying to get those animals out. Right? So, what is the point of the prohibition? It cannot be no animals, period. It has to be some animals, but not all animals. So, maybe it should mean no animals that I cannot control and that would be more dangerous than a normal park animal. So if you have I don't know, tiger, you cannot bring that tiger into the park. But if you have a chihuahua in a leash, sure, why not? Or you can do the opposite and say, no, no, no. Of course, it doesn't mean that. It specifically means no pets, right? Because what other animal would come into the park but a pet? There are no tigers coming into the park. It's pets that are banned. So no, you cannot bring your chihuahua, even if it's not dangerous. So you can change the meaning of a rule that's supposedly simple, no animals in the park, to mean many other different things. And we see this in real life. The US in its constitution has an article that says that international law is the supreme law of the land. Is international law the supreme law of the land in the United States? No. The US Constitution has been analyzed by the US Supreme Court, which said that local law, US law, is more important than international law. So the Constitution says international law is the supreme law of the land, but the court read it as international law is not the supreme law of the land. Why? Because the law is radically indeterminate. So because the law is radically indeterminate, courts tend to read that in a specific gaze. And that specific gaze is usually aligned to those with money, to those with power. In the case of the international system, to states, which are the primordial subjects and the most powerful subjects in international law. So international law is biased towards states. I'm not biased towards states. I don't like states. If anything, I don't think I'm biased, but if anything, I'm biased towards human rights, biased towards self-determination. So I have a conflict with the system. The system is biased towards someone that I am not biased to. So if that system says this state did not commit genocide, that to me only means that the radically indeterminate rule of genocide has been interpreted to save a state from genocide, from a finding, from an accusation of genocide. So why would I give that credence? I still think that that is wrong and that that state committed genocide. And sure, not at the ICJ, but that doesn't mean that it didn't commit genocide. That doesn't mean that that is the law. That doesn't make it truth. It just makes it what the ICJ says. And the ICJ, like any other legal scholar, like me, like I can be wrong, the ICJ can be wrong as well. That's my view of law. That's how I see the law. I see the law as a tool that like changes, that is that can be malleated. It's malleable um, in response to power and money. I don't see the law as an objective arbiter for international disputes. XV78N says, this seems interesting to read France's press release. Wonder if it allows for readings that twist what is apparent. I think that's more politics than law. So I would distinguish between the radical indeterminacy of law from politics. I think what France did with that statement was to say, well, first of all, we don't know how much that statement was tied to the ceasefire in Lebanon, so that France could get credit for that ceasefire. We don't know. But what I think happened was France knows, the government of France knows that France does not decide who gets arrested and who does not. Courts do in France. Who issues arrest warrants? Not the president. The courts do. So it was very little cost for France to issue a statement saying, oh no, Netanyahu should not be arrested. Because it's not up to them. It wouldn't change anything in the ground. But it would allow them to go to Netanyahu and say, see, we said this. Now what do we get in return? So I think that was politics. I don't think that was like I don't think that had to do with the relative indeterminacy of the law. I don't think they made a legal claim to that. I don't think they were trying to change the way that the law of arrest warrants was interpreted in France. I just think they were negotiating something with Netanyahu, even if it's just brownie points with Netanyahu. Iconoclast 94 says Noura Erakat has the same view. She says that she's cynical vis-a-vis the law. Yeah, I mean Noura Erakat and myself, we both belong to kind of the same critical legal studies school, so I'm not surprised. Yeah, it's a pretty fundamental. So I guess so. If you are a use naturalist, you believe that for the law to be law, it needs to also be moral, right? So that's a key tenet of use naturalism, that moral fact is inherent to legal facts, right? So if a law is immoral, let's say slavery, that's not really law, and you're meant to disobey it. That's use naturalism. If you're a positivist, you believe that law has nothing to do with morals. The law is independent of morality, and so slavery is that. It's a law that says slavery is legal. And you cannot say that that law is not law. What you can say is that that law, that is law, is immoral. And so you have a moral duty to disobey it, whatever happens to you. And so you oppose the law on moral grounds, but that law is still law. Whereas a use naturalist would tell you, no, 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 that's not law. That wasn't really law. That was something else. And so use naturalists and positivists have fought with each other for like centuries about what is and isn't law. Critical legal scholars, we believe that, I mean, this idea that the law is somehow objective, but both use naturalists and positivists have, is sort of naive. Like, it's not that there is a law that says slavery is legal and that is that moral or immoral. Why is there a law that says that slavery is legal? Because slavers hold power in societies. So slavers get to determine what the law means. What if there's a rule that says all men are created equal, right? In the U.S. Constitution, sorry, Declaration of Independence, all men are created equal, right? How that is interpreted, how that is read, depends on who has the power to read it. And of course, slavers have the power in slaver societies. So how do they read all men are created equal? All men, parenthetical, that are white and free are equal. Right? So it's not so much whether the law is moral or not, it is more that the law follows power. If you believe that, you're a critical scholar. Now, how you identify that power also is relevant. So, on the one hand, if you believe that that power is mostly determined by racial dynamics, you are most likely a critical race scholar. If you believe that that power is mostly determined by colonialism, you're a post-colonial scholar. If you believe that it's a little bit of everything, you're most likely what most critical legal scholars believe. A set of oppressions like sexism, colonialism, racism define how the law is shaped. That is critical legal studies. And when you focus on specific oppressions, you can say this is a critical race uh, um, this is a critical legal race article, or this is a feminist legal article, or this is a post-colonial legal article, right? So that's how you um, sort of exist as a critical scholar, which is the tradition that I most subscribe to. If you're interested in reading this, I guess there's two books that you should read on this. I mean, there's a bunch, but like one that you can read is, let me see if I can find exact. I don't remember the name. Hold on. Uh, Hold on. I'm trying to find it. Mm, mm, where is it? Oh yeah, here it is. It's called Knowledge and Politics by Roberto Mangabeira Unger. Let me see if I can um get you a link. So Roberto Mangabeira Unger is a Brazilian scholar. Um, I'm pretty sure he had the book available. Hold on. Where is it? Where is it? Trying to find it. I can't find it. Well, if I find it, I'll put it in the Discord group. Mm, yeah, I can't find it. uh, I'm really pissed off that I can't find it. Yeah, well, I can't find it. But yeah, I think it's Knowledge and Politics by Roberto Mangabeira Unger, and then the other one would be From Apology to Utopia, which is how Martikos Keniemi grabbed Mangabeira Unger's theory and applied it to international law. Rosa Batones is another unread book. So From Apology to Utopia, I can find. So this is a very big book, so approach it with care. By Martikos Keniemi on critical legal studies applied to international law. Um, there is so you can find a summarized version here, and this one's open access, so you will be able to read it. Um, and yeah, and you can do that. So essentially, that's how it works. Like if you are a critical legal scholar, you believe in law as power, essentially. So I would agree with Nura Erakat's view on this, pretty much verbatim. XV78N says, have you followed the ICJ hearing for the advisory opinion this week? It somehow relates to some of these approaches. I haven't, honestly, I haven't had the time. It's too big of a case. It's like 90 submissions, so it's kind of insane. So no, I haven't. But yeah, right now the ICJ is trying a case, is deciding an advisory opinion on climate change, which is huge. But yeah, I really haven't had time to keep up with that. It's just too big of a case. When the decision comes out, I might do a stream about it once I read it. Did I find it? I found it. Yes. Okay, this is a Rada Manga Beta Ungar's article. Well, a book actually. So this one is also really complicated to read. Ah, I'm so happy I found it. I was going crazy. Um, it's really complicated to read, but it's really interesting once you get the hang of it. It essentially says what I said. That the theory follows the law. Actually, there's another one that's theory. The law follows power. Sorry. Um, yeah, I think that's it. Yeah. Well, yeah. I mean, that's it. That's my view on the law, actually. So yeah. And and that's immunities, really. So yeah. I mean, I guess all that remains is, do you have any questions? Rosova says UNSC question. I always thought that the UNSC resolutions are binding for its members, but it appears that only resolutions invoking Chapter 7 of the Charter are binding. Is that correct? Um, I mean, there's been some debate recently about that, but I'm of the opinion that, UN Security Council resolutions are binding. Um, Chapter 7 ones can authorize use of force. Um, so yeah, I do not subscribe this, like, oh, there are some resolutions that are binding and some resolutions that are recommendations. I don't subscribe to that, but in all fairness, there are various views on this. Um, so yeah, I guess the legal answer is it depends on who you read, basically. But I guess yeah, Chapter 7 ones definitely are binding, in all circumstances. Because to me, what the Security Council does when it doesn't want to say something bindingly is it issues a presidential statement. Um, Article 25 UN Charter says Mare Liberum. Let's see. So, mm, it's here. Hold on. Article 25. Member states of the United Nations agree to accept and carry out the decisions of the Security Council in accordance with the present charter. Yeah, yeah. I mean, this is what I believe as well. But like recently, there was this like decision by the Security Council that the United States was reading as, oh, this is just a recommendation. So I don't understand that. I don't agree with that. Um, and yeah, I agree with Maria Liberum here that yeah, UNSC resolutions are binding. But I there is some I have read some people that have said that depending on the language of the resolution, they can be like recommendations. I just don't agree with that. But thanks, Maria Liberum. That was a good save. Uh, okay. So, do you guys have any more questions? We're getting close to our usual 2 hour mark, so you guys let me know. Otherwise, I'll go eat. Okay, then. Honestly, I think I covered everything. On Legend of Carlos is like excited. I think I covered everything on like immunities, and that was a nice conversation about critical international law. So I guess we can start closing the stream a little early, like 10 minutes early. Um, unless anyone has a question. And well, at least on my end, I'm happy to be back. Sorry that I missed the past two streams. And yeah, just as a reminder, I will be streaming on Wednesdays until next week. After next week, I go back to Thursdays in my regular time. Sorry about the change. It's just busy weeks ahead of us for all academics, and hopefully this was interesting for you guys. I I don't know how interesting it is for you guys to just read decisions like this, but it's the only way that I could think of doing it. Um, Essentially, now you know that if someone tells you that Netanyahu has immunities, you can tell them no because of the Jordan appeals decision. um, and yeah, I mean, hopefully you found value in this. I definitely did. Your questions are always super interesting. I appreciate it. Uh, Iconoclast, I'm glad that you found it interesting. It still blows my mind that there's like a group of like 16 people right now on a regular Wednesday just reading ICC decisions. So thank you so much. I'm really happy and proud of the community that we're building. And yeah, tell your friends so that um, do we can come closer to that nice 30 to 40 people that we had 10 days ago watching the streams. Um, and yeah, thank you guys for being here. Thank you Rosova for being here and Magic of Carols. Really appreciate it. I will see you on Sunday at I think 5 o'clock GMT, and then on Wednesday. And I still need to update you guys on the FIFA thing, so I will do that soon. But okay, thank you so much for being here. I'm not gonna close the stream. Have a good night. Bye.